Good morning, Your Honors.
Good morning. Hold on.
I'm sorry.
All right, let's proceed.
Good morning. May it please the Court. My name is Attorney Dave Rotundo, and I represent Mr. Pena. In continuation of this argument on mootness, we have very similar circumstances in my case.
They're actually a little different, aren't they?
Well, the facts are different.
I don't mean that the crimes are different, but there were other bases for the finding of the violation than simply the being charged with the other offense.
Yes, that's true. Apparently, the judge found also technical violations.
Did not the judge say, I'm not relying on those other offenses because they haven't been tried yet?
Well, I would argue that the Commonwealth in their response stated that the judge indeed relied on the actual offenses. However, I think for the purposes of sentencing, the judge stated that he wasn't going to rely on the uncharged
I see.
conduct.
I'm sorry, I didn't.
The uncharged or the pending?
Pending conduct. In our case, I would ask the Court to look at this issue of mootness, to actually look at the issue that was on appeal. In our case, the issue on appeal was whether Mr. Pena was denied assistance of counsel. And it's our position that the fact that he pled out to these charges would not make that issue moot in this case for a variety of reasons. First, his sentence is still he's still serving his sentence. He has not completed his sentence. Second, if the Court were to decide that this issue is not moot and it was remanded back to the trial court, Mr. Pena, the Commonwealth would no doubt enter the convictions. He would be violated. However, Mr. Pena would at that point have the assistance of counsel in the sentencing phase of the hearing, of which he did not have assistance in this case. And that's another issue that we do have on this appeal. So for those reasons, and I realize I have limited time and I have another argument, I would say that Mr. Pena's issue and more persuasive facts in his case would not be moot. And I would also like to point out that the Court's suggestion, just based on a purely collateral consequences type argument, even in a case where the defendant has pleaded guilty and has served his sentence, I would argue even at that level that the appeal should not be moot because, again, these judgments and these sentences imposed can be used in later proceedings against the defendant.
But it's a foregone conclusion that your client violated his probation, right? I mean, it's a foregone conclusion. So what's the collateral consequence?
The collateral consequence is, well, I would...
Beyond the fact that he committed these new crimes,
right.
which, of
First,
course, isn't any collateral consequence subsumed in the fact that he's now pled guilty to all these additional crimes?
Well, I think there's a number of collateral consequences. First, I think that he was not afforded an attorney. I think you have to look at the issue that was on appeal. I mean, the whole argument is the issue on appeal is moot. The issue on appeal is moot in light of the fact that he pleaded to these convictions. If you look at Commonwealth versus Fallon, I mean, what was the issue in that case? The issue was whether the main issue in the case was whether there was a correct standard used during the probation surrender hearing, whether it was the correct probable cause standard. And the Court ruled that, well, he subsequently pleaded out under a beyond a reasonable doubt standard. Therefore, he subsequently was convicted at trial on a greater standard, and therefore he has no issue in the case because
There is no issue that he violated his probation, right? There's no issue anymore. And that it's established beyond a reasonable doubt.
Yes.
Right.
But in our case, I think that in that case, the issue was moot for those reasons. But in our case, our issue deals with whether he was denied his right to counsel. And
Well, I agree that's a separate issue. I'm just trying to understand the collateral consequences.
well, I would argue that the only collateral consequence would be that if this case was sent back, he would have the opportunity in the sentencing hearing to have a competent attorney re-argue his sentencing and potentially to get him a reduced sentence.
Now, do we know from the record from here whether or not Judge Gaziano found him in violation for the new offenses or found him in violation for the technical violations?
I think based on the technical violations and the new offenses, he was found in violation.
And where is that in the record? I couldn't find it.
I believe the Commonwealth has cited that in their brief.
But the brief does not constitute the record. Are you conceding?
No, the record is, it's clear in the record that during the probation, I think it was the 30th of April, at the end of the close of the evidence, he stated that, he summarized the offenses and stated for those reasons, and he was finding him in violation. However, he did state that during the sentencing phase that he was not considering the
Conviction.
charged conduct.
Yeah.
Now, going back to the issue of whether or not there was a colloquy given with regard to his waiver of his right to counsel, decision to proceed pro se, whose burden is it to, I mean, we don't have the record of what happened before Judge Ball when he was allowed to go pro se and given standby counsel. Whose burden is it to show that he indeed was provided a colloquy?
I would argue it would be the burden of defense counsel, appellate counsel in this case. I do not have that record. However, I do not have that transcript of that proceeding. However, I would argue that even if he was given a colloquy at that time, I would argue that even if he was given that colloquy, that Judge Gaziano should have re-colloquized him at the hearing, and for numerous reasons. First, the record reflects that this case was continued numerous times for Mr. Pena to obtain private counsel, not to represent himself pro se. He always had the intention of retaining private counsel. And I believe on 1/15/08, before Judge Ball, the record reflected that after hearing and colloquy with the defendant, the court orders defense counsel's motion to withdraw be denied. So defense counsel didn't want to act as standby counsel. She denied that motion. Subsequent to that, now, this is what Judge Gaziano is relying on Judge Ball's statement in the record, colloquy, to mean that he was given an intelligent and voluntary colloquy. And I mean, we don't know that. And I realize that if we had the record of that day, we would know that. Now,
So since it's your burden, we have to accept then or assume that Judge Ball indeed gave a colloquy when she allowed him to go pro se and proceed standby, correct?
Arguments. Well, I would also state that there was no evidence of written waiver in the file either. Although that's not conclusive whether it was given, just to point that out. But my argument essentially is that
even if she did, Judge Gaziano had to do it again.
yes.
Okay, but I mean there's a practical problem with that is that this trial had been postponed many a time to give him opportunity for retained counsel, and if he were to say, do you give him that colloquy, he may say, no, I wish to have counsel appointed, and then counsel would have to be appointed, and the case would have to be postponed again.
Well, I don't think so in the present case, because he did have standby counsel, and I think if you read in the transcript, the judge stated to Mr. Pena, he said during the surrender hearing, he said Mr. Pena, he had elected to represent himself, and that he had standby counsel, and Mr. Pena replied, and I think which is indicative of his understanding that he didn't think he was proceeding pro se. He stated that he did not elect to represent himself, and standby counsel did not mean he had counsel. My only argument is, at that point, the judge could have recolloquized him and appointed standby counsel at that point. Standby counsel had been his counsel for the last
But
couple
you
of months.
said the judge could have reappointed, he was standby counsel.
He was standby counsel, but Mr. Pena did not know that he could have had him as his appointed counsel.
Full counsel. Well, he had already had him as his. But what do you do when Mr. Pena says repeatedly, I don't want court-appointed counsel. I want private counsel, and I want time to get it. He's given time again, time again, time again. Doesn't get it. The judge says, I conclude that you're here, you're not really interested in having private counsel. You simply want to delay these proceedings, and I'm not going to allow it to go on anymore. You've got standby counsel. We're going forward.
Well, I think he had every right to say we're going forward, but it's my position that he had an obligation to recolloquize him at that point, and I would just, cite Brewer v. Williams, duty of trial court to protect the accused's right to counsel, indulging all reasonable inferences against waiver of counsel. And, there are other cases, Ninth Circuit cases. There's no case in Massachusetts. McCormick v. Adams, U.S. v. Hansis, Ninth Circuit cases, 2010 cases that deal with.
So let me say, so let's assume he says, yes, I hear you, Judge. No, I don't want to represent myself. I want counsel, but I want private counsel, and I'm not going to accept public counsel.
Then at that point,
Is that
you
a
would have
waiver?
to proceed pro se. At least he gave him the option.
Okay.
All right, thank
That's
you.
all I have. Thank you.
Yes, ma'am.
Good morning, Your Honors. May it please the Court, Hella Sachser on behalf of the Commonwealth. This Court should affirm the revocation of the defendant's probation or alternatively dismiss the defendant's appeal as moot. Here,
Can I ask you, don't you think it would have been helpful if we'd had the colloquy that Judge Ball did on, was it January 8th or 15th?
on, I believe it was January 2nd of 2008, absolutely, it would have been helpful.
That January 2nd colloquy was not the colloquy in which he went standby. That was the colloquy as to whether or not he was going to allow the motion of standby counsel to withdraw.
I'm sorry, Your Honor, I believe that happened on January 15th.
Look at the record.
Yes, on page 13 and 14 of the Commonwealth Record Appendix, it says on January 2nd, 2008, the bottom of page 13, the probation, the counsel is ordered to represent defendant as standby. And I believe in the absence of a transcript of that proceeding that my brother could have procured, because this is only 4 years ago, we must assume that on that day things proceeded as they should have, and that Judge Ball, in fact, conducted a colloquy with the defendant, and that she determined that he had properly waived his right to appointed counsel.
But there's no reference to a colloquy in that docket entry.
Not in the docket entry. That is correct.
So you point to this as showing there was a colloquy given.
I'm sorry. No, Your Honor. I refer to a colloquy that is mentioned on January 15th,
right,
which is
that's the one that orders defense counsel's motion to withdraw be denied.
That's correct. However, Rule 310 of the SJC rules regarding the appointment of counsel says that Judge Ball can only appoint standby counsel if she has determined that the defendant has waived his counsel. And I would like to point out that my brother did not make the effort to obtain any of these transcripts, which he could have. And I think the reason is because they would probably spell out that the defendant properly waived his right to counsel on that, on those occasions. In addition, however, the proceedings before Judge Gaziano are entirely sufficient to demonstrate that the defendant here voluntarily waived his right to counsel. Judge Gaziano noted that he had given the defendant ample opportunity and continued the case for the sole purpose of obtaining private counsel. The defendant reiterates multiple times that he cannot proceed by himself, that he cannot represent himself, that he needs private counsel, and that he is working on it but has not been able to obtain that attorney without making any specific reference to steps he has taken. And Judge Gaziano said, no, you've had the opportunity and you're doing this simply to delay. And according to Commonwealth versus Appleby 389, Mass 359, Judge Gaziano has the discretion to determine that he will no longer allow the defendant to delay the proceedings, even if that means that the defendant will proceed without counsel. So there is a valid waiver of counsel in this case.
Can I ask you a question, though? First of all, you've cited to Rule 3.10. I don't see that in your brief. Is this a new argument you're making?
That's correct. I don't cite it in my brief. My brother notes it in his last footnote. I did not make that argument in the
so
brief.
you're suggesting that when the defendant claims that he had not waived his right to counsel, that it is his burden to produce the colloquy? I mean, isn't it always the Commonwealth's burden, once that has been raised, to demonstrate a knowing and intelligent voluntary waiver?
It is. In this case, however, the defendant does not challenge anything that occurred before Judge Ball. He simply challenges Judge Gaziano's decision to not ask the defendant again whether he would like appointed counsel. And so that argument is simply not before the court. And in that case, it cannot be the Commonwealth burden to produce something to rebut an argument that's not raised by the defendant.
Do you think this is moot?
Yes, I do.
Because?
Because the defendant has pled guilty to 10 indictments for which he was noted, and in response to Judge Gantz's earlier question, the transcript of the final surrender hearing, July 29th, 2008, sets out exactly what Judge Gaziano determined the defendant's violations were. And he does mention the technical violation, and he goes through a detailed description.
He does or does not?
He does, yes,
Okay.
of the offenses upon which he relied, and those match up exactly with the later indictments to which the defendant pled guilty.
So here's the problem, though. The judge goes through, and I was a little confused, but I assume you agree that the judge, in finding that there had been a violation of probation, took into account not only we'll call them technical violations, failure to appear, failure to pay fees, but also some of the pending charges, because he made specific findings with regard to the defendant having been stopped and having the stolen property on him and all of that, right? So that's part of the, I find, a violation part.
Yes.
But is it fair to say the judge then said, but with respect to disposition, I am not considering any of that. I'm only considering the technical violations?
I think the judge has to do that. He cannot take any crimes for which the defendant has not been convicted into account in...
Can't? What
No.
if there were only what if the only violations were the new criminal activity, which is often the case? You mean the judge couldn't then take that into account in deciding how to dispose of the
That was my lot.
violation?
I think my lot was only the...
Yeah.
He can, however, in the way that defendant framed that argument before the court, that the judge did not rely on the new charges in violating.
No, it did rely in violating.
Yes.
It did not rely in then disposing of the case. You know, I find he's violating.
Yeah.
The judge says, I find the following, and that these are violations of his probation. And he talks about both the technical and the substantive. And then he moves on to the disposition part and says, I'm not going to take into account any of the pending cases, which were these cases, and I'm only going to take into account the other violations. So that's different, right?
It is. However, if I might point out, the defendant in his brief does not raise a claim with regard to the sentencing.
But if he'd had counsel at that point, and the only thing the judge was considering was his failure to appear at some appointments and his failure to pay a fee, might not that have turned out differently?
It might have. And I think there is with regard to the mootness, there is a clear distinction between, first of all, the mootness of the finding of violation. And I think that part will be rendered moot by a subsequent guilty plea or a subsequent conviction that is upheld. After that, there is the disposition aspect. And in a case where the defendant is represented by counsel, that aspect is also rendered moot by virtue of the fact that the judge's sentencing, the judge's disposition after finding a violation is discretionary. In a case where the defendant is not represented by counsel, the sentencing or the disposition aspect of the probation revocation may not necessarily be moot. It would be moot if, excuse me, the sentence received as a result of the probation revocation is entirely subsumed within the subsequent sentence for the new charges, or it has been.
It's still something of consequence on the person's record.
But in a case where the defendant is represented by counsel, I think we must assume that if he's not challenging it specifically, that everything, the fact that he had an attorney renders that entire scenario moot. And I would point the court to the case of State versus Singleton, which the Middlesex DA cited in her brief. It's 274 Connecticut 426, a 2005 case in which the Connecticut Supreme Court reached exactly that conclusion, that in a case where a defendant is represented by counsel, the finding of violation is moot. That also renders the sentencing aspect of it moot.
Okay. I'm now thoroughly perplexed by your argument. Is it your view that, I gather he's still serving time on the violation of probation?
In my case, yes, he is.
And you're saying it's still moot even though he's right now in jail because of that?
I am saying that, assuming for the sake of argument that he had not waived his right to counsel as the defendant here did, in my case, the sentencing part may actually not be moot, because the sentence the defendant received here for the probation revocation is in fact longer than the sentence he received for the new offenses for which he was sentenced to 3 years and a day. Here he received a 4 to 6 year sentence for the possession of burglarious tools, which is longer. He will be serving that longer, not by much. We asked the Department of Correction for help, and they informed us that the defendant is currently serving that sentence for about 3 weeks longer than his the sentence for the new convictions. However, if he had not were not serving that sentence, he would be able to accumulate good time and reduce his sentence on the new conviction.
It's not moot. You agree it's not moot?
Well, it is in this case because the defendant waived his right to counsel.
Who has the burden? Who has the burden to show that he waived the right to counsel?
Well, normally the Commonwealth has to show that the defendant voluntarily waived it, but under the circumstances of this case, Judge Graziano's determination that the defendant was simply delaying the proceedings.
That's looking at the merits of his argument, isn't it? I'm sorry, I just don't see why you say it's moot. You get to the mootness by saying that the merits of the argument he's making to us don't exist.
Well, I think the mootness is a two-part. It needs to be considered in two parts here. First, the finding of violation, which is the only relief my brother is seeking. The only relief he's seeking in this case is that this court determined that vacate the finding of violation. That aspect of it is moot as a result of the later convictions. The sentencing part here is moot because the defendant properly waived his right to counsel. Arguably, in a case where the defendant is not represented by counsel, the sentencing could potentially not be moot, although the finding of violation
So you're
part
saying we
would-
have to reach the merits to determine whether it's moot?
only with regard to the sentencing.
Well, counsel, we'll have to leave it there. Thank you very much.
Thank you.